Good afternoon, everyone. I am Tony Rafter, Deputy Chair of the Queensland Law Reform Commission. Welcome to the Survey Findings webinar, which will introduce the Criminal Defences Review's Research Report 1, Community Attitudes to Defences in Homicide and Assault Cases and the Penalty for Murder in Queensland. The Community Attitudes Report paints a rich picture of contemporary attitudes held by Queenslanders with respect to criminal culpability, domestic and family violence, and the appropriateness of the mandatory sentence of life imprisonment for murder. This is an important piece of research which the Commission hopes will contribute to research and policy development beyond the work of the Commission. The report has been prepared for the Queensland Law Reform Commission by the team of researchers joining us today: Dr. Hayley Boxall, Professor Lorana Bartels, Professor Kate Fitzgibbon, and Rebecca Ruddy. The Commission is grateful for the excellent work of the research team, who have been supported by the Social Research Centre. The analysis and findings of the research are those of the research team and not the Commission. First, an acknowledgement of country. We begin by respectfully acknowledging the traditional custodians of the lands on which this event is taking place here in Meanjin, Brisbane. That is the Yagara and Turrbal peoples. We also acknowledge the traditional custodians of the various lands on which our online presenters and audiences gathered. We respect and honour their elders, past and present. We also acknowledge and welcome all First Nations peoples who are attending today's event. Just a couple of housekeeping matters to begin with. Given the nature of this review, some of the content discussed during this webinar may be confronting or distressing. Of course, you are free to leave the webinar at any time, and should you require support, please see a list of available services that are displayed in the chat panel. We encourage you to participate in this webinar. If you have a question for the presenters during the webinar or comments, please submit it via the question and answer facility, not the chat function. All questions put to the panel will be de-identified and other viewers will not be able to see your questions. If you are experiencing any issues with the stream, please notify us of that through the chat. This webinar will be recorded and published at a later time on the Queensland Law Reform Commission website. Now to an overview of this review. In November last year, the former Attorney-General gave the Commission terms of reference to review and investigate the operation of particular criminal defences. The Queensland Government asked us to examine and make recommendations about particular defences in the Criminal Code, namely self-defence, provocation as a defence to assault and partial defence to murder, and the partial defence to murder of killing for preservation in an abusive domestic relationship, and also domestic discipline. We are asked to recommend if any changes are needed to reform the law, practice or procedure concerning those defences, and as recommended by the Women's Safety and Justice Task Force, the terms of reference require us to consider the mandatory penalty of life imprisonment for murder. This webinar coincides with the publication of the research report and a supporting fact sheet. These are available on the Queensland Law Reform Commission website. The link was available via the QR code on the opening screen and will be shown again at the conclusion of this discussion. This research has enabled the Commission to fulfil specific requirements in the terms of reference with regard to the need to ensure Queensland's criminal law reflects contemporary community standards. The Commission is committed to understanding the diverse views from across the state of Queensland to ensure that our law reform recommendations are made having properly considered community attitudes. The aim of this webinar is to present some of the key findings of the Community Attitudes Research Project. We are fortunate to be joined by the researchers who collectively have a great depth of expertise and experience across the areas of criminology, criminal law, domestic and family violence law, and research. Dr. Hayley Boxall is a research fellow with the Australian National University and has undertaken research on domestic and family violence and sexual violence for over 10 years. She has undertaken research and published extensively on domestic, family and sexual violence. Prior to joining the ANU, Hayley managed the Australian Institute of Criminology's Violence Against Women and Children Research Program. Lorana Bartels is a Professor of Criminology at the Australian National University. She is a member of the Tasmanian Sentencing Advisory Council and Director of the Justice Reform Initiative. Lorana's areas of expertise include criminal and sentencing law and domestic, family and sexual violence. Kate Fitzgibbon is a Professor with the Faculty of Business and Economics at Monash University and Honorary Professorial Fellow with Melbourne Law School. Kate is an international research leader in violence against women and children, perpetrator interventions and the impacts of policy and practice reform, and has advised on homicide law reform and family violence reviews in Australia and internationally. Her research has been cited by the High Court of Australia. Rebecca Ruddy is a First Nations researcher with deep cultural connections to the lands and waters of far north Queensland, belonging to the rainforest and saltwater peoples of Mamu, Djirbal, Yindinji, Gugu, Yamartha nations. Ms. Ruddy is a researcher at the Centre for Social Policy Research, where she has endeavoured to elevate marginalised voices in research and policy development. Rebecca's research passions include social justice, human rights, restorative justice, and transformative justice. Ms. Ruddy embraces a First Nation standpoint in her approach to research activities. We're very fortunate indeed to have such well-credentialed presenters today. Thank you very much to our presenters. Just a reminder to please feel free to ask questions in the chat function. I'll now ask our presenters to address us.
Thank you so much. I'm just going to get my slides up. Yep. Thank you so much for having us. We're very excited to share the findings from what has been a major undertaking, which we've been conducting since the beginning of the year. To kick us off, I would just like to pay some acknowledgements to the people who have supported us to get to this point. So the QLRC for their support and input into the project, our Indigenous Advisory Group members, Davina Hickling and Napu Namok, for their input into the project at different stages, and obviously the research participants who gave their time to take part in this very important piece of work. So when we were asked to really understand community attitudes towards the use of partial and full defences, it's actually a very difficult thing through a piece of research to really get an understanding of what the community thinks, particularly because you have to think about things like social desirability bias, as well as how will people respond to different types of questions. So you can ask someone, what do you think about provocation as a defence? Or you could ask them, say, what they think about a particular scenario that they're presented with. So the international research has really identified that to really get an understanding of what the community thinks about a particular thing, so in this case, partial and full defences in cases of assault and homicide, the best possible option is to provide them with scenarios, so real world examples where they are required to interrogate the information that they're provided with and to provide some information about what they think would be a good outcome in that case if a defendant was charged with assault or murdering someone, and then trying to kind of unpack that with them in terms of what factors they're taking into consideration. So what we did in brief is a vignette study where we surveyed 2,500 people residing in Queensland, 18 years and older, who were recruited through online research panels. And we asked these individuals to consider 8 different assault and homicide scenarios and to provide us with information about what they think would be a good outcome and why they reached that determination. But we also asked survey participants about their attitudes towards domestic and family violence, victimisation histories and their experiences attending court, as well as a range of different socio-demographic characteristics. We also did focus groups with 58 community members recruited through social media and community-based organisations, and they participated in about 12 focus groups across the data collection period. And really, these two research methods talk to each other in really important ways. So the survey is about breadth. It's about getting a very large number of people to have input into the survey and into this, I guess, this research question of what does the community think about the use of different defences. But the focus groups really helped us to interrogate those responses and to unpack with community members why they held those views, what factors they were taking into consideration as well. So talking just very briefly about the scenarios. So the scenarios were generated based on the international literature that's done similar kinds of work in international jurisdictions, particularly the UK, as well as Australian case law. And we also workshopped these scenarios with the QLRC. So for the assault scenarios, we had 5 that were broadly testing community attitudes towards 3 different defences: self-defence, provocation, and domestic discipline. One of the really interesting things that we can do as part of a vignette study is that we don't provide all participants with the same scenario. So all the scenarios don't look the same. What we can do is actually vary different scenarios by key pieces of information to see whether or not that changes what people think about the best possible outcome in this case. So take, for example, scenario 1, which involved 2 acquaintances getting into a fight at the park. So the blue text is the standard text, but the orange text are key pieces of information that we varied. So for example, 50% of people who completed the survey were told that after Donald punched Vaughan, he then proceeded to stomp on his chest and face with his feet. However, 50% of participants were not told that information, and that provides us with a really important point of difference that we can kind of compare what different members of the community thought was an appropriate outcome in those 2 different scenarios. Well, the homicide scenarios, there were 3 scenarios that tested 3 different defences: self-defence, killing for preservation, and provocation. And again, just to kind of say, we varied those vignettes on key pieces of information to see whether or not it changed what people thought was an appropriate outcome in those scenarios. So let's get into the key findings. So there are about 12 key findings in the report that we describe in a lot of detail, but with the time that we have, what we wanted to do is just to provide a bit of a high-level overview of some of the key findings as they relate to specific defences. So looking at provocation, what we found from the focus groups and the surveys was that there was very little support for the defence of provocation, where the defendant's conduct was motivated by anger, jealousy, or control, and this particularly came through in cases involving domestic and family violence. So in 2 of our scenarios, provocation could have been raised as a defence if the defendant was charged with assault or murder. So in scenario 2, a man harmed his female partner after a dispute where she either slapped his hand away or she was observed having an affair with a work colleague. Regardless of the provoking conduct, his response was to throw a glass at her. In scenario 8, which was a homicide scenario, an intimate partner killed their spouse, who they believed was having an affair, and this was following an argument which involved different forms of provoking behaviour. So what you can see here is that the large majority of survey participants and also the focus group participants were very unenthusiastic about the idea that the defendant would have their charge downgraded or their sentence downgraded on the basis of provocation. So 96% of people in scenario 2 in particular said that the defendant should be found guilty of assault. When explaining why they held these views, participants described the defendant as being motivated by a desire for control, and that there should not be protection in the law to downgrade his culpability as a result of that. In particular, there was some views from the community that a successful defence of provocation in these cases could be viewed as devaluing the victim's safety or their life, and also telling the defendant that they are not responsible for controlling their behaviours. However, even though there was very high levels of condemnation amongst the community for those two scenarios in relation to the defendant's behaviours, what we did see from the analysis was that there is still some pervasive gender norms and attitudes towards domestic and family violence that influence what people think is a good outcome in these cases. So in particular, what we saw for both scenario 8 and scenario 2 was that people who had victim blaming and minimising attitudes towards domestic and family violence were more likely to say that the defendant should have access to a partial defence of provocation. And also in scenario 8, what we saw was that the nature of the provoking conduct that the victim engaged in did influence views of culpability. So in particular, what we found is that when the victim was described as saying that she did have an affair and that her new partner was better in bed, so very high levels of provoking behaviour, that participants were more likely to say that the defendant should have access to the defence of provocation, particularly when compared with scenarios where, say, the victim denied the affair and asked for a separation. So what we kind of see here are these kind of ideal victimhood narratives coming through about who is a more deserving victim and when those defences of provocation should be able to be accessed. And then finally, just on provocation, what we found as well is that the community does not support provocation as a defence to assault if there is a risk of significant injury to the victim. So this came through as part of 3 scenarios where provocation could be accessed in the assault kind of space. But scenario 1 is probably the most helpful in terms of unpacking this for us. So what we found is that in scenarios where the defendant was described as stomping on the victim's chest and face, there was much less appetite for him to have access to provocation as a defence. And this came through as part of the focus groups as well, with a number of focus group members talking about how the defendant could have killed the victim by stomping on his chest and face. And similarly, we found that when the victim was described as requiring a stay in hospital and receiving a broken jaw as a result of the assault, there was much less appetite for the defendant having access to a partial defence of provocation as well. On that note, I'm going to hand over to Kate, who's going to take us through domestic discipline. Thanks, Kate.
Thank you so much, Hayley, and thank you so much to everyone for joining today. As many of you may be aware, there is a defence of domestic discipline in Queensland law, and that falls under the current review. So to examine community attitudes to this defence, we used a vignette that involved Dora, a mum, and Vicky, her 11-year-old child. And the participating community members were told that a year ago, Vicky was diagnosed with ADHD, and that one of the rules in Vicky's family is that kids cannot have their mobile phones in their bedroom after 8 p.m. One evening, Vicky was in her room watching a video on their phone, and she's been doing that a lot lately, despite her parents' repeated requests not to. At 8 p.m, Vicky's parents told her to hand over the phone. Vicky refused and swore at them. To punish Vicky, her mum, Dora, took the phone and slapped Vicky on the thigh. So we use this vignette to test community attitudes towards the defence of domestic discipline in the context of the family. And what we found was that community members had high levels of empathy for Dora, who was often described, particularly in the focus groups, as a struggling mum. And participants often questioned who would benefit from Dora being charged and convicted of assault in this scenario. So participants were generally supportive of a defence to assault for parents, but in the caveat of where minimal force was used to discipline a child. Participants also showed broad support for alternatives to criminal prosecution where parents use minimal force to discipline their children. So focus group participants didn't support the use of violence against children for discipline, but they did think that a criminal justice system response was not appropriate in this scenario. And there was a range of different alternate options offered by focus group participants, including particularly education and familial support, particularly in scenarios where the child was described as having a disability. There was a range of empathy and alternates offered. Looking at the next slide, perceptions of culpability amongst community members were definitely influenced by the level of force and the harm that was used by Dora in this scenario. So participants were more likely to say that a parent should be found guilty of assault if they perceived that there was a potential harm to the child, and if that harm was greater than a minor incident. So, for example, in some of the focus groups, we changed the scenario to have the parent using an implement, or where the parent left bruising or slapped the child in the face. And in those situations, community members were more likely to want to see a guilty outcome for a parent that uses violence in that context. There was a question raised, which really remained unanswered, of whether one-off minor incidents of violence can be experienced as harmful or whether they would not be. Moving to the next slide, we also looked at how the defence of domestic discipline can apply in education contexts. As some of you may be aware, there's been questions in Queensland surrounding the use of the defence by teachers. So during the survey and focus groups, this was a manipulator that we twigged, where we could change the situation to ask community members their views on Dora's response if Dora was Vicky's teacher and not her mum. We found that the community supports teachers' ability to use force for the purpose only of last resort management of control, but not for discipline or correction. And that was a really important distinction. In the survey, 30% of participants said Davina, as it was in that vignette, should be found guilty where she was described as using minor force, so grabbing a hand or the shirt of the child for the purposes of control. In the focus groups, there was really strong condemnation when a teacher was described as slapping a child on the thigh with the key purpose of punishing her. And there was a clear sense that a criminal justice system response was warranted in that scenario. I'm going to move us now to looking at the application of defences for victims of domestic and family violence who kill. As many of you may be aware, looking at the list of people, I'm sure several of you, there has been significant community debate around the use of partial and complete defences and how they are accessible for victim survivors of domestic and family violence who kill an abusive partner, particularly where those lethal actions occur in the context of fear. So within this project, this involves the complete defence of self-defence, the partial defence of killing in self-preservation, and the partial defence of provocation, each of which have been subjected to considerable debate. So to examine community views on the defences that should be available to victims of domestic and family violence who killed, we used in particular one vignette involving Diana and Vernon. And survey and focus group participants were told that Vernon had abused his partner Diana for a number of years. He had called her names, he had told her she was worthless, and he had also punched, slapped, kicked and shoved her, resulting in bruising, black eyes, hospitalisation for broken bones. A couple of times his abuse had led Diana's family and friends to call the police, but Diana had always declined to make a statement. On the afternoon of the offence, Diana and Vernon were in the kitchen together and they started to argue. Vernon said to Diana that if he killed her, nobody would miss her. In response, she couldn't take the abuse anymore, so she waited. Her. Throughout our project, there was significant discomfort amongst community members about convicting Diana of murder. There was a lot of questions raised, particularly through the focus groups, about what would it serve? What justice would be achieved if Diana was to be convicted of murder? In particular, questions surrounding the imminence of the threat of violence really appeared to influence attitudes in both the survey and the focus groups around culpability. So we found that where there was no imminent threat, the community were more likely to view Diana's lethal actions as indicative of planning and believe that the victim should have had other options. So, for example, 25% of people would convict Diana of murder if she waited until her abusive husband went to sleep, whereas this reduced to 14% favouring conviction when she killed him immediately in response to the argument. If we move to the next slide, interestingly, what we did find was that women, victim survivors of intimate partner violence, and people aged 55 years and older were more likely to think that Diana, the defendant, should be found not guilty of murder. Throughout the focus group discussions, we really found that the lived experience of participants was often used to understand Diana's mindset at the time of killing her abuser, and whether and why she may have felt that this was a legitimate and only safe option. In particular, we found a lot of participants spoke about the entrapment of victim survivors within coercive controlling relationships. And we've spoken in the report about the importance of domestic and family violence informed jury directions and expert evidence in cases involving a history of abuse by the deceased, so that jury members who are making these decisions can understand the nature and impact of violence, including social entrapment. I am now going to hand you over to Lorana to discuss the findings relating to self-defence.
Lorana, you're on mute.
Okay, thank you. So we tested self-defence in relation to 4 scenarios, 2 in relation to assault and 2 homicide scenarios. And because there are 4 scenarios, I won't go through all of them in as much detail as Kate and Hayley have about the previous ones, because broadly it didn't matter so much whether we how we manipulated the variables. The findings were that community attitudes do align closely with the traditional application of self-defence and the way the law is currently framed. So in scenario 1, which was the one we presented at the start, where the 2 acquaintances get into a fight, we were testing both provocation, which you've heard about, and self-defence. And the participants who thought Donald should be acquitted did refer to self-defence when explaining their decision. And the ones who thought he should be found guilty referred to Donald's perceived ability to escape as part of their decision-making, as well as the proportionality, or lack thereof, of his actions. So inferentially, we can sort of think that, well, they're understanding what those elements of self-defence are about, and in that instance, they weren't convinced that it applied at such as to justify an acquittal on the basis of self-defence. This last point really seemed to be important for participants in that scenario. Those who were told that Donald had stomped on the victim's chest were more likely to say he should be found guilty of assault, controlling for a range of other factors. And that also emerged in the focus group discussions. Participants described the act of stomping as being out of proportion to the threat and as a clear indication of high culpability. So we're getting that sense that the community intuitively understands the elements of self-defence. Obviously, we weren't testing them. Do you understand all these elements? But when presented with a scenario where self-defence could, on those facts arise, they either thought if they intuitively went to those issues around proportionality and option for retreat. Scenario 3 involved a football fan assaulting another fan who's heckling him and his girlfriend, and that mostly aimed to assess community attitudes also towards provocation. But the 15% of participants who believed that the defendant in that case should be acquitted, again, when in first they would think he was acting in self-defence, and there subtlety variations in how that scenario is presented, but there where most of the respondents again believed that he should be convicted, they were speaking about how he had other options available to him. He could have moved away, could have called security, and that the victim did not pose an immediate imminent threat. So we can infer from that again that they're understanding what the law requires, and they're in agreement essentially with it. Turning now to the homicide scenarios, there were 2. One involved Daisy, a victim of sexual assault, who then kills the perpetrator. And 21% of the survey participants said she should not be found guilty of any offence, i.e. not murder and not manslaughter. And when they were asked to explain why they believed that she should be acquitted, several participants did describe her act as being in self-defence against an imminent attack from the victim. The participants who believe she should be found guilty of murder or manslaughter were asked to explain their reasoning, and they spoke about the option for escape and how her response was disproportionate to the threat posed. Although there were a number of participants who suggested she may not have intended to kill the victim, hence downgrading the offence to manslaughter. So overall, these results highlight that traditional considerations of self-defence generally well accepted and understood by members of the community. They seem to fairly consistently grasp the relevant factors for the defence of self-defence, necessity to use defensive force, reasonableness, incorporating considerations of options for retreat, and proportionality. And with regards to provoked self-defence, which is, of course, a quirk of the Queensland law, which I wasn't terribly familiar with previously, they were able to factor that into their assessment of reasonableness, which is how self-defence law operates in jurisdictions other than Queensland. Now, the finding from 1 in 5 participants in the survey that Daisy should be acquitted of killing the victim who was attempting to sexually assault her does raise some interesting issues, because the sexual assault is not actually, aligned with how the law is currently framed, and so it does suggest that there may be scope or need to amend the law in relation to an actual or apprehended sexual assault, rather than self-defence being limited to apprehension of death or grievous bodily harm. And of course, one could potentially on certain facts argue that grievous bodily harm could ensue from certain sexual assaults, but to make it more explicit that in those sorts of circumstances self-defence could be available, subject to considerations of necessity and reasonableness. So that was an interesting dimension that arose on that factual scenario. There was also a scenario you heard about before in relation to Diana, the domestic violence victim who killed her perpetrator. And that suggests that there might be scope to consider a partial defence of excessive self-defence, another manslaughter option that exists in some jurisdictions. Whether that's necessary in addition to the killing for preservation, is debatable, but obviously in that scenario, potentially having more options available for the jury to consider might result in, depending on the facts, a less harsh and more just outcome, where excessive self-defence, is truly the right outcome, because the person was acting in self-defence and they might not understand the minutiae of the domestic violence circumstance. Although, as Kate said, having that evidence before the court is really, really important in those situations. Now I'm going to turn to the sentencing dimension in relation to murder, because this is an interesting reference in that although we were focused mostly on defences, we were also asked to consider the mandatory life sentence for murder. And obviously things have moved on a little bit in Queensland, as I understand it, very recently. It's a very hot topical issue at the moment, especially in relation to young people. But it doesn't actually suggest that this is in fact aligned with community sentiments when they're presented with vignette scenario, vignette that describe facts as opposed to do you believe in mandatory sentencing. So the position in Queensland is the same as in the Northern Territory and South Australia, in that murder attracts a mandatory life sentence. Western Australia has presumptive life sentences for murder, and then in the other jurisdictions, of course, the maximum sentence for murder is life imprisonment, but this is discretionary rather than mandatory. Now, the survey and focus group findings revealed that the Queensland position is not, in fact, supported by the community, and instead the community expects sentencing to reflect the culpability of defendants, and this may vary across factual scenarios. In particular, scenario 6, the domestic violence one, of participants who said that Diana should be found guilty of murder, and that was only 19% of survey respondents. 72% said there were factors that should reduce her sentence. And those that proportion was consistent regardless of the characteristics of the scenario. So, for example, the nature of the abuse that she was subjected to. In scenario 7, of participants who said Daisy should be found guilty of murder, so that was the sexual assault situation, almost 36% said there were factors that should reduce her sentence. And the variables manipulated in that situation, so whether she used a bottle versus a knife to kill the victim, whether she was angry or frightened upon having had an unwanted sexual advance, again did not present as strongly determinative factors in relation to that. Scenario 8 was the only homicide scenario where most respondents supported a murder conviction, and we haven't gone through all of these scenarios. But even there, 10% said that there were factors that should reduce the defendant's sentence. And I can't say that they were particularly strong mitigating factors in that defendant's case, but even there, 10% did. In the survey, there was another way that we tested this, which was we presented respondents with 4 different murder scenarios. So there was a party to an offence. So, two parties are involved in a situation that goes badly. One does the killing, and the other, of course, is under joint criminal enterprise responsible for it. Should they receive, what penalty should they receive? One where someone kills for a benefit, one under reckless indifference, and a mercy killing of a terminally ill and much loved spouse with their consent. Unsurprisingly, that last case was the real outlier in people's views. So they were presented in each instance with 2 of the 4 cases, and they were manipulated. So they got varying of those 2 cases. And depending on which 2 they got, 83 to 80% of respondents considered that the mercy killing case should result in a different sentence to the party to offence, kills for benefit, or reckless indifference cases. Obviously, under mandatory sentencing for murder, all of those would result in a life sentence. So the respondents didn't necessarily understand how mandatory sentencing works, but nearly all of them saw that there were in fact differences in culpability, perceived there to be differences in culpability between those scenarios. During focus group discussions, there was significant division amongst participants about their support for mandatory sentencing for murder. So when they were asked the general question, do you support mandatory sentencing? Many participants originally said, yes, they did, on the basis that killing someone was a very serious offence and should attract a significant penalty. And some participants espoused the view of a life for a life in cases of murder. Notably, for many of these participants, their support for mandatory sentencing was linked to their concern about judicial officers' ability to apply discretion appropriately in cases of homicide. And those concerns were mainly raised in relation to cases involving domestic and family violence, where they questioned the court's ability to understand the dynamics and impacts of such violence and how perpetrators of abuse may weaponize the criminal justice system to reduce their sentences for killing their partners. The inclusion of a mandatory sentence for murder in the legislation was viewed as a protection against these potential miscarriages of justice. Conversely, for some, because of their lack of faith in judicial officers to get it right, they were not supportive of mandatory sentences because they could imagine someone killing their partner in what was actually self-defence, being charged with and convicted of murder, and then being sentenced to life imprisonment. But for most focus group participants, they were questioning the merit of the standard when applied in practice. There was a general view that not all murders are the same, with focus group participants making comparisons between cases that they believe should attract a serious penalty, for example, serial killers, compared to other cases which should not, for example, where a domestic violence victim kills their perpetrator. So there was a need for sentencing to reflect the individual culpability of defendants, raised even by community members who initially said they were supportive of mandatory sentencing. And these findings align with Warner et al.'s observation that views on mandatory sentences tend to be, it's a quote, divided, malleable and inconsistent, and depend on the methodology adopted. I'll now pass to Rebecca to lead us through the final findings.
Thanks, Lorana. So here we looked at the variation in attitudes towards defence within community. So perceptions of culpability varied across the community concerning key factors such as gender, age, victimisation history, attitudes towards domestic and family violence, and also First Nations people status concerning Aboriginal and Torres Strait Islander people. These differences reveal how personal experiences and systemic influences shape communities' understanding of justice. But today, we only have time to explore the gendered perspectives from women, men, and also trans and non-binary participants, as well as the unique perspectives from First Nations people. Here, female participants consistently held defendants to a stricter standard of accountability, particularly in intimate partner violence and domestic and family violence cases. Women were also critical of excessive force where severe injury was caused, reflecting their strong stance against disproportional violence, as well as women also demonstrated significantly lower victim blaming tendencies and minimizing attitudes. So there was a greater awareness of the gendered impact of violence, especially evident in cases involving intimate partner violence survivors. For example, 67% of women supported manslaughter, 16% supported the acquittal for survivors who killed abusive partners, and these findings reflect the deeper understanding of coercive control and also the systemic barriers. Women's responses consistently highlighted the importance of trauma-informed sentencing approaches, as well as they recognized the psychological and systemic dimensions of violence, and their perspectives emphasized the need for a more nuanced and context-specific evaluation in relation to culpability. In contrast, men were more lenient in their assessment of culpability, particularly in cases involving provocation and the use of physical force as discipline. So this leniency often reflected a focus on proportionality and situational context of the crime, with men viewing violent responses as understandable or justified in cases of provocation. Men, as well, perhaps showed less understanding of the psychological and non-physical impacts of domestic and family violence, particularly coercive control. And this gap was evident in their responses to Diana's case. Men frequently questioned why she didn't leave her abusive partner, focused on perceived non-violent alternatives. And that was the gap in their awareness, perhaps. Proportionality was also a recurring theme in men's response, often assessing whether the defendant's action aligned with the perceived level of threat. And men were more forgiving of reactive violence, but remained critical of excessive responses. They also, however, they did acknowledge the disproportionality in relation to the Vaughan scenario, particularly on stomping on the victim's face. Compared to women, men demonstrated potentially, so they had, and they were more likely to justify the actions of the provocation, aligning with traditional gender norms around conflict and accountability. Moving forward to the trans and non-binary perspectives, participants, they brought in unique insight into the study, highlighting the systemic risks and premeditated violence often targeted at their demographic. So their experience revealed how interpersonal violence was deeply rooted in societal prejudices, which compounded their vulnerability. These participants called for a nuanced, context-specific evaluation of culpability, recognizing that traditional legal frameworks often failed to account for their unique dynamics of violence that they face. And then they also emphasized the need for a broader legal framework that addressed and sustained targeted violence rather than narrowly focusing on the immediate physical threat. But however, there was obviously a limited amount of participants in this particular area, but their findings definitely highlight the urgent need for inclusive legal policies that better protect and represent all community members. Moving forward, in this particular scenario, when we looked at Indigenous status and culpability, we found in the case looking around Derek, we found that Aboriginal and Torres Strait Islander participants were less likely than non-Indigenous participants to find Derek guilty of assault. And this is in relation to the sporting event scenario where heckling and as a form of provocation was presented to the participants. 63.8% of Aboriginal and Torres Strait Islander people versus 85% of non-Indigenous people. So Indigenous participants empathise with Derek, viewing his actions as a justified response to public provocation. This reflects potentially the collective and individual experience of systemic racism and harassment that is often experienced by Aboriginal and Torres Strait Islander people, particularly in public spaces, and sporting events being one. While many non-Indigenous participants suggested that Derek could have walked away or called security, these responses perhaps overlook the reality and the nature of the colonial and historical kind of injustices when we're thinking about in relation to security, police, and perhaps them not having their best interests taken into consideration. For example, another scenario, an Indigenous participant actually viewed Vince's provoking actions as a form of violence, where we can see when an Aboriginal participant said, "Vince assaulted him if you ask me. Why should he use abusive words on him because they aren't the same, but because they aren't on the same team?" On the other hand, one Torres Strait Islander participant explained that Derek did what any of us would do in that situation. Shut the idiot up. The other guy deserved it. And in contrast, a non-Indigenous participant stated that people have a right to go to a sporting event and cheer and support their team without being harassed by some idiot. But at the same time, these responses illustrate how potentially cultural and systemic experiences shape perceptions of culpability, and further research would have to be done in this situation to kind of understand the intersections between culture and also perceptions of culpability in relation to provocation. Continuing on with Indigenous status and culpability, we explored the differences in victim blaming and minimizing attitudes, which found that Indigenous participants were less likely to minimize domestic and family violence, reflecting a deeper awareness of its harm, and their attitudes towards non-physical abuse, however, were similar to those of non-Indigenous participants. Indigenous perspectives often reflected their understanding of the broader dynamics of violence, and it's important that recognizing these realities is critical for the development of an equitable and inclusive justice framework. And passing on to Hayley.
Sorry, on mute. Nothing else to add really, other than to say that the report can be accessed here. It is a very big report, but we're very, very proud of it, and it's a big piece of work, and we're looking forward to answering any questions that anyone might have in the audience. So thank you very much.
Thank you, Hayley, Kate, Lorana and Rebecca for your very interesting presentations. Your research has produced fascinating perspectives on these matters. It was interesting to learn that the community intuitively understands self-defence. Community support for defences and partial defences for victims of domestic violence who kill an abusive partner is another important finding. It is also interesting that most respondents did not think provocation should provide a defence, especially where the provocation is words alone or where offending is motivated by anger, jealousy, or wanting to control another person. Significantly, the findings suggest that the community does not think every murder should attract the same punishment, and that sentencing for murder should reflect the individual factual circumstances of each case. The Community Attitudes Report gives the Commission valuable information to inform our work going forward. We now have time for questions.
Okay, the first question we've got from the audience is, was there any discussion or findings arising from the survey or focus groups regarding minimum mandatory sentencing?
So I can say from the survey that we didn't ask about what a mandatory sentence should be in certain cases. And I'll throw the rest of the question over to Kate, because from my memory, we started a number of the focus groups asking that question, and the feedback we got was just quite overwhelming just because it was so disparate. Was that right?
Absolutely. So in the focus groups, we ended up focusing predominantly on the mandatory sentence and what that meant, and looking at whether there should be a mandatory term or whether individualised sentencing would be favoured by the community. I think one of the challenges that we were grappling with throughout the focus groups is that we had some members of the community that had legal backgrounds, but these were predominantly people that were not au fait with the criminal law and the inner workings of sentencing. So nutting out the distinctions between mandatory and minimum proved quite challenging. But I think the really important factor that came through extremely strongly from the focus groups was that the community supports individualised sentencing that reflects the circumstances of the offence committed.
Okay, thank you. The next question asks, was there any discussion or analysis of non-criminal legal responses of conviction for homicide? So things like disqualification from a benefit on a will or on intestacy?
No, so that wasn't raised in the survey or the focus groups, which is, we had a lot to get through. I'm sure that would have been a very interesting additional kind of question to ask, but it wasn't asked and it wasn't raised voluntarily by any of the participants, unfortunately.
Okay, thank you. Is there a way to reconcile the findings concerning lack of support for mandatory sentencing with a belief that the community want mandatory sentencing for murder?
Lorana.
I'm happy to speak to that. I think it goes to that issue of what are you asking people and what do they understand? And I've been involved with public opinion research on sentencing for many years. And, there is this innate response of, oh, judges get it wrong and, it's always too lenient. But when presented with facts, they're much more likely to come up with responses that are concordant with what judicial officers do. Many people on this call will be familiar with the jury sentencing research led by Kay Warner, which I've been involved with. And, when they're presented with, jurors, who are members of the public, of course, are presented with information that's much more close to what the judge would have, and in that project, it's the judge's sentencing remarks. They will generally say up to 90% of cases that the judge's decision is appropriate. So I think we need to be very careful not to take the sort of question of, do you want mandatory sentencing or are sentences tough enough, and at face value, and make sure that our policy decisions are based on an actual understanding of the facts in particular cases. And I also refer to a relatively recent report, I think 2023, of the Queensland Sentencing Advisory Council, where they did some public opinion research. And again, members of the public didn't actually understand what mandatory sentencing meant. And when they learnt that meant that the judicial officer had no scope whatsoever to reduce a sentence in, you know, where there were strong mitigating circumstances, their support for it fell.
Okay, thank you. Our next question asks, what might we learn about the type of expert evidence that might be required in cases of intimate partner violence and homicide by the usual victim to facilitate the possibility of self-defence?
I'm going to let Kate answer that one because she's unmuted, so she's obviously ready to go.
I know. Apart from putting my hand up and just looking really eager, that was my signal. Thank you so much, Hayley. And I'm extremely conscious that we have some individuals on this webinar who are extremely well versed in this topic, and thinking of Stella Tarrant in particular. But it really does show us, the findings from this study, the importance of expert evidence in informing jury decision-making in cases of involving histories of intimate partner violence, particularly where defences such as the complete defence of self-defence are raised, which we know traditionally has been a difficult defence for women who kill an abusive partner outside of the traditional kind of responding to an immediate threat circumstances, that it has been challenging for women to successfully raise a defence. Yet, as our findings consistently showed from the focus group, where individuals have a history of intimate partner violence, they understand the social entrapment, the isolation, the learned behaviour that impacts a woman's decision in these circumstances. So it's really important to ensure that that information is being conveyed to a jury to inform their decision making where partial and complete defences are offered.
Just to kind of add on to that, I think it's the specifics around dispelling community myths around why didn't she just leave, because I know that I'm being asked at the moment to provide expert evidence to explain behaviours that are very consistent with the social entrapment model, but on the face of it may appear to be the actions of a victim who does not fear for their safety. So things like asking to have charges dropped against an abuser, changing orders, picking up their partner who's imprisoned for assaulting them, those kinds of behaviours. So really actually kind of going, this is not necessarily indicative of someone who is not afraid. It is very consistent with a social entrapment lens.
And even just to provide, just in the broad understandings in the First Nations space, where a lot of First Nations women are victims in this particular area, you know, there's a lack of trust, you know, in relation to the police. There could also be in relation to community as well, from the areas that they're at. There's all different types of lenses in that space of coercive control that we just don't necessarily understand, or like in literature at the moment, and it's like unexplored territory. And perhaps it might be of interest to consider those factors as well, of why women do not necessarily try, like in relation to explain like the coercive control and that social entrapment side of things, but exploring it from all of those dimensions.
Okay, we've got a follow-up question about dispelling myths. Has there been any research about the effectiveness of jury directions that you're aware of, compared with expert evidence on the topic?
Kate and Lorana, I'll hand that one over to you. Nothing that I'm aware of.
It's incredibly hard to do jury research. You can't do it, obviously, without permission from attorneys general. And there's that's hard to come by. But even then, you know, I'm certainly not aware of any Australian research that explores that. You could do mock research in this regard, but I'm not aware of any on that specific point. But yeah, I'm certainly not aware that anyone's asked actual jurors what do you find more compelling, hearing from an academic who knows about these things, or hearing from a real victim who knows about these things, or anything to that effect, if I've understood the question correctly. But we really don't know that much about how this stuff is taken on board by jurors, and that's a really valuable and valid point. And I think in the first instance, one would be looking to mock juror research to be doing this rather than research with actual jurors, just as a matter of practical reality.
Thank you very much. I'm about to return to our Deputy Chair to wrap up today's webinar, but just a comment that's come in from our Chair, Fleur Kingham. She extends her thanks to the research team for the quality of your work, as well as for this very informative presentation. This is a critical source of information for the QLRC, which we will draw upon in developing consultation proposals and ultimately our recommendations. So thank you from us all. And back to you, Tony.
In concluding, I'd like to endorse the comments of the Chair, Fleur Kingham. Thank you so much to Hayley, Kate, Lorana and Rebecca for taking the time to present your important findings today. Your research has enabled the Commission to fulfil specific requirements in the terms of reference with regard to the need to ensure Queensland's criminal law reflects contemporary community standards. The Commission is committed to understanding the diverse views from across the state of Queensland to ensure that our recommendations are made having properly considered community attitudes. Going forward, we anticipate releasing a consultation paper calling for formal submissions in early 2025. We will then produce a report and make any recommendations to the Attorney-General by the 1st of December 2025. A reminder that if you require any assistance or support, to reach out to the services listed in the chat and also on our closing screen. There is a QR code on the screen which links to the subscription information on our website to register your interest in the review. We encourage your continued involvement in this review. Engaging with people who have an interest, expertise or experience in the laws under review helps us to better understand the issues, practical challenges and potential solutions. This is critical in developing recommendations for reform that are based on the best available evidence, are practical and capable of implementation. So thank you.